Hi guys, and I welcome you to the second episode of our legal aptitude previous question paper solving. We are solving the question paper of 2021, and if you can hear my voice properly and look at the presentation on the screen, please give me a very quick tech check in the chat window so that we can proceed further. Okay. So I hope I'm properly live right now, and let us directly proceed to the first question of the day, or the 76th question in the question paper and 16th question of our series. The first question is here on your screen. Which among the following is not a constitutional body in India? క్రింది వాటిలో ఏది ఒక రాజ్యాంగ సంస్థ కాదు? ఫైనాన్స్ కమిషన్, హ్యూమన్ రైట్స్ కమిషన్, ఎలక్షన్ కమిషన్, or Union Public Service Commission. So what is the answer? So the answer is Human Rights Commission. So what exactly is a constitutional body or Rajyanga Samstha ante emiti? So constitutional body is a body which is directly mentioned in the constitution, which means that it comes with an article. So ప్రతి రాజ్యాంగ సంస్థ అనేది రాజ్యాంగం ద్వారా ఎస్టాబ్లిష్ కాబడింది, ప్లస్ దానికి ఒక ఆర్టికల్ అనేది ఉంటుంది. సో లెట్ us see what exactly the articles for other constitutional bodies. So finance commission is a constitutional body under article 280 of the Indian constitution, and then we have human rights commission is not a constitutional body. It is a statutory body which is established under the Human Rights Act, whereas election commission is a constitutional body which is established under article 324 of the Indian constitution. UPSC or Union Public Service Commission is again a constitutional body which is established under article 315 of the Indian constitution. So this is what you have to know from this question. So now let us proceed with the next question, or question number 77, which is there on your screen. Which of the following is not considered as a feature of the basic structure of the Indian constitution? Which of the following is not a part of basic structure? Secularism, rule of law, presidential form of government, or judicial review? క్రింది వాణిలో దేనిని భారత రాజ్యాంగ మౌలిక స్వరూపంగా భావించరు? ఇస్ ఇట్ లౌకికవాదం, సమానత్వ సిద్ధాంతం, అధ్యక్ష తరహా పాలన, న్యాయ సమీక్ష? So the answer is presidential form of government, because India does not follow presidential form of government. Rather, we follow what is known as parliamentary form of government. So we follow what is known as parliamentary form of government. Don't worry if you don't understand what is parliamentary form of government. I'm going to explain them in our subsequent classes. Whereas secularism or laukikavadam or rule of law, which is samanyaya siddhantam, or judicial review, which is न्याय समीक्षा, all of them are a part of basic structure of the Indian constitution. As I have explained in the previous classes, that basic structure is nowhere mentioned in the Indian constitution. It is a judiciary evolved doctrine which was evolved in 𝐀𝐻𝐿 Bharati versus state of Kerala. So we're going to discuss about this in our upcoming classes, so don't worry about this. So let's proceed with the next question, which is here on your screen. Justice J.S. Verma Committee 2013 was concerned with. Justice J.S. Verma Committee 2013 దేనికి సంబంధించింది? Is it amendments to criminal law, amendments to civil law, environmental law, or constitutional law? So what is the answer? The answer is amendments to criminal law. So this Justice J.S. Verma Committee was appointed after the 2012 Nirbhaya gang rape case which happened in Delhi. So after this particular gang rape case, J.S. Verma Committee was appointed in the year 2013 to review amendments to criminal law. So before this, we have learned in 1997 there were Vishaka guidelines which were there in Vishaka versus state of Rajasthan. So we are going to discuss about those cases in our upcoming classes. So for the time being, remember that J.S. Verma Committee is related to amendments to criminal law. Next question, or question number 79. The judgment in Shaira Banu versus Union of India is on the issue relating to. షైరా బాను వర్సెస్ భారత ప్రభుత్వం కేసులో ఇచ్చిన తీర్పు దేనికి సంబంధించింది? Is it invalidity of bigamy among Muslims, or is it protection of waqf properties, or maintenance of divorced Muslim women, or invalidity of triple talaq in Muslim law? So if you know the answer, you can write it down in the chat window. I don't know why the definition of the video quality is very poor in my mobile phone. So let's see. I'm doing it from my laptop, but in the mobile I'm seeing it, the video quality is very poor. I don't know why. So invalidity of triple talaq in Muslim law. ముస్లింలలో ఉన్న తక్షణ 3 సార్ల తలాక్ చట్టబద్ధతను సంబంధించిన కేసు, దట్ ఈస్ షైరా బాను వర్సెస్ యూనియన్ ఆఫ్ ఇండియా. In Shaira Banu versus Union of India, triple talaq was declared invalid, whereas maintenance of divorced Muslim women is also a very landmark case, that is Shah Banu versus Union of India. Shah Banu is related to maintenance, whereas triple talaq is related to Shaira Banu is related to invalidity of triple talaq. So after this particular case, Parliament has enacted a very special legislation, that is the Muslim Women Protection of Rights on Marriage Act. Next question, question number 80. The expression fourth estate generally refers to. సాధారణంగా fourth estate అని ఎవరి గురించి సంబోధిస్తారు? Is it NGOs or is it bureaucracy, press or civil societies? So what is the answer? The answer is press. So in India this particular term is generally referred in India. So the first estate, second estate and third estate, we already know, that is legislature, executive and also judiciary. So these are the three estates which are there, whereas fourth estate is the press or the media. Next question is appearing on your screen, question number 81. The expression SAL as used as a substitute of PIL by certain jurists denotes. PIL అనగా ప్రజా ప్రయోజన వ్యాజ్యానికి ప్రత్యామ్నాయంగా కొందరు న్యాయ కోవిధులు SAL అనే పదాన్ని వాడుతారు. దీనికి అర్థం ఏమిటి? See, look at this question. I don't know why, because the term PIL is expanded in the Telugu version of the question, but in the English version of the question they've given it only as PIL. I don't know why. So the answer is social action litigation, or social action litigation is a substitute which is used to PIL by certain noted jurists. So you know that the term PIL is again not mentioned in the Indian Constitution. It is again a judicially evolved doctrine, and we know that Justice P.N. Bhagavati and Justice Krishna Iyer, they were the progenitors of PIL in India. And I've discussed a lot of PILs in our previous classes, and I'm going to do the same in our upcoming classes as well. Next question, in which year was the WTO established? WTO ను ఏ సంవత్సరంలో స్థాపించారు? So the very straightforward answer is 1995. 1995. 1995 is the right answer, 1995. Next question is here on your screen. ICCPR in the context of human rights denotes. మానవ హక్కులకు సంబంధించి ICCPR అంటే ఏమిటి? So what is the answer? It is the International Covenant on Civil and Political Rights. So there is no much difference between a convention, covenant and all of these things, but here is just given these options to confuse us, but the answer is International Covenant on Civil and Political Rights. So whenever you are learning any abbreviation, please make sure that you are learning each and every term of it and don't confuse between these options, okay? Because options are very confusing, so please take a note of this. Next question. The United Nations Conference on the Environment in 1972 was held in dash city of dash country. What is the name of the city and also country? 1977వ సంవత్సరంలో ఐక్యరాజ్య సమితి పర్యావరణ సదస్సు ఏ నగరం మరియు ఏ దేశంలో జరిగింది? So the answer is Stockholm, which is in Sweden. Stockholm అనే సిటీ which is in Sweden. ఈ దేశంలో యునైటెడ్ నేషన్స్ కాన్ఫరెన్స్ ఆన్ ఎన్వైరన్మెంట్ 1972లో జరిగింది. Next, and the not last question, but 85th question is here. An agreement with a minor under the Indian Contract Act is. ఒక మైనర్ తో చేసుకున్న ఒప్పందం ఇండియన్ కాంట్రాక్టు యాక్ట్ ప్రకారం. So the answer is void ab initio. So what is the meaning of void ab initio? Void ab initio is void from the beginning. So మొదటి నుండి శూన్యమైనది, which means it cannot be enforceable from the beginning. So what is a valid contract? Valid contract, something which is enforceable by law. Voidable contract is something which can be enforceable but at the wish of either party whose consent is not free. So illegal is something that is not legal. Next question is here. International Criminal Court is located in. For those who have attended my class at 6:30 p.m. today, you will be in a position to answer this. So the answer is The Hague, which is in Netherlands. So today we talked about the International Criminal Court. We also talked about Geneva Convention. We also talked about what are war crimes. So International Criminal Court is located in The Hague, which is in Netherlands. Is India a party to International Criminal Court? Is India a party to International Criminal Court, which is, the Rome Convention? It's not a party, but India does not, entertain or recognize International Criminal Court. India is not a party to this, to the Rome Convention, which has, established this thing. Which one of the following is not considered as intellectual property? క్రింది వాటిలో దేనిని ఒక మేధో సంపత్తిగా పరిగణించరు? So what is the answer? It is very simple and quite self-explanatory. Hello Vaishnavi. I'm not looking at the chat window because I have to, look on this one. If you know the answer, write it down. I'll look it at the end. Okay, so the answer is agricultural land. So agricultural land is not an intellectual property. It is a physical property. Okay, it is a physical immovable property, whereas invention, which can be patented, logo and literary work, both of them, logo can be declared as a trademark and literary work can be declared as a copyright. So all of these are intellectual property, and agricultural land or vyavasaya bhumi is not an intellectual property. Very good Vaishnavi. Next question. Yeah, so this is one of the question last year. For those who did not attend my classes, they have attempted this wrong in the examination. But for those students who paid very close attention in my class, they have answered this correct and they got advantage of 1 mark. So the Hyderabadi dish which was granted registration as a geographical indication of goods is వస్తు భౌగోళిక సూచికగా రిజిస్ట్రేషన్ చేయబడ్డ హైదరాబాదీ వంటకం ఏది? So the answer is Hyderabadi Halim and not Hyderabadi biryani. Last year I have explained this particular thing. Hyderabadi biryani is not granted geographical indication. The answer is Hyderabadi Halim. So please take a note of this. There are chances of repetition of this particular question in your upcoming law exams in India. So please take a note of this. Very good Vaishnavi. Let's proceed with the next question. When an imprisoned person is sent temporarily from jail for a certain purpose, it is called. ఒక జైలు శిక్ష అనుభవిస్తున్న వ్యక్తి ఒక నిర్ధారిత ఉద్దేశ్యం కోసం తాత్కాలికంగా విడుదల కావడాన్ని ఏమంటారు? Is it bail or anticipatory bail, parole or pardon? This is again a question where a lot of aspirants make a very big mistake. The answer is not bail. The answer is parole. So when you are releasing someone temporarily from bail, that is known as parole. The amount that you keep as a security to the magistrate, whenever you are releasing on parole, the court will ask you to deposit some X amount. It might be 10,000 or 20,000. That amount is known as bail. Okay, the surety is known as bail, but your release is known as parole. Okay, anticipatory bail is something which is released, something which is given before you are arrested. You are anticipating your arrest. You are arrested, you are asking, bail from the court and you are getting this thing. Pardon is, an executive power which is vested with the president. We are going to discuss about pardon and various other powers, clemency powers of the president and governor in our upcoming classes. Very important and last question of the day is appearing on your screen now. The Supreme Court of India laid down the doctrine of prospective overruling in which of the following landmark judgments? Shankari Prasad versus Union of India, Sajjan Singh versus State of, this is actually Sajjan Singh versus State of Rajasthan, they given as UP, anyway, that's not the thing. Golaknath versus State of Punjab and Keshwananda Bharati versus State of Kerala. భారత సుప్రీం కోర్టు తన సుప్రసిద్ధ తీర్పులోని ఏ తీర్పులలో ప్రాస్పెక్టివ్ ఓవర్ రూలింగ్ అనే సిద్ధాంతాన్ని గుర్తించింది? For the students who have watched all the videos on this YouTube channel, you will be in a position to answer this for sure. So the answer is Golaknath versus State of Punjab. In Golaknath versus State of Punjab, the Supreme Court has laid down the doctrine of prospective overruling. So what do you mean by doctrine of prospective overruling? So doctrine of prospective ruling simply means that the judgment applies from the future date. So let us say if judgment is delivered on 5th of March, then it will be applicable from 5th of March and not retrospectively, that is from 4th of March or before this thing. So whatever happened before 5th of March, we are not bothered about it. So this judgment applies from 5th of March. So if it is applied from the previous date, it is known as doctrine of retrospective overruling. So doctrine of prospective overruling is evolved in Golaknath versus State of Punjab. We have discussed about our previous cases, that is Shankari Prasad versus Union of India, in which Supreme Court held that Parliament can amend any part of the Constitution. Same judgment was reiterated in Sajjan Singh versus State of Rajasthan and not Uttar Pradesh. And in Keshwananda Bharati case, Supreme Court has delivered the landmark judgment in which it has evolved the doctrine of basic structure, which is very, very important restriction or limitation on the amending power of the parliament. So this brings me to the last question of the day. So in tomorrow's class, we are going to discuss, not tomorrow, but maybe on Monday or Tuesday, we will be dealing with the next 15 questions from this question paper. And until next time, please make sure that you are liking this particular session and subscribe to the channel and stay tuned for more videos. And tomorrow morning at 9 a.m. a video will go live. It is not a live, so it will be published on the channel where I'm going to make a very special announcement about something.